Welcome to the I Got Fired podcast, a podcast for people who've been fired or afraid that they might be. My name is Tom Spiegel. I am founder of the Spiegel Law Firm and host of the podcast. Today, I am starting a series on the steps in the litigation process after things are filed in court. So within reason, sort of soup to nuts, kind of what you would see from everything where you initiate the lawsuit to when the trial happens, if there is a trial. So, but before I begin, little disclaimer, if this is intended for educational purposes for you, it's not intended to be specific legal advice for your case. If you need that, then you got it. You should hire a lawyer. All right, so let's get started. So in most disputes, including employment disputes, there are a lot of steps that happen before we get to actually filing in court. And we've covered a lot of those on this podcast. As I have discussed before, in many cases, you have to file. If it's a discrimination case that's under federal law, you have to file with the EEOC, or the Equal Employment Opportunity Commission, before you can even file in court. That's got to have occurred. And even in those cases where you don't, there's often a lot of back and forth with the company, attempts to settle, a demand letter before we get to the complaint filing stage. It could be, many months into your case. But let's assume all that has happened. You've sent the demand letter through your attorney to your employer, former employer, and didn't get a positive result. Perhaps you had, you went to the EEOC. If it's a case that you did have to file with the EEOC or some other administrative body, perhaps you did that. You had mediation and that was unsuccessful. And now the only, step left to take, unless you're just going to walk away from the case, is to go to court. So the first thing that you have to do, the opening shot, is what's called the complaint, filing the complaint. And this is it's a document that kind of sets forth, what the lawsuit is about. It's not a full narrative. It doesn't have to include everything that can come up in the case. And there are different strategies about how to file it. The best way to do this, generally, you just need, you need the caption. You need to show why this is the court you should be in, to show what's called venue, essentially that the dispute happened this location. For instance, if we were representing a client who had been fired in Arlington, Virginia, and we were filing a complaint, we would say, and we were filing in federal court in the Eastern District, we'd say, the events took place in Arlington, Virginia on this date, therefore venue is appropriate. So you got the venue. You've got one of the more important parts are the statement of facts. And this is where you tell what happened. And usually they're numbered paragraphs. So it doesn't, necessarily, it's not just like you write a letter, that sort of thing. Usually numbered paragraphs that set forth, what happened. I worked at this company on these dates. I was terminated on this date. I received an email that said that the reason for my termination was due to my pregnancy status. Very unlikely that you'll actually see something like that, but those would be the facts that set forth that you were fired for an improper reason. And then you would set forth, damages that you might have incurred, that you've been out of a job, so you suffered emotional distress, those sorts of things. So you got the facts provision. And then you've got the laws. So what laws do you think were broken? In this case, we would say, count one might be a violation of Title VII of the Civil Rights Act of 1964. There could be multiple counts involving the same set of facts. So we might also put that this is a violation of the Virginia Human Rights Act. If there were other things that had gone wrong in this case, let's say that you were, this woman was also paid at a lower rate than a man doing the same work, we might also assert an Equal Pay Act claim, and that would be count 3, and so forth and so on. So when I say there's a strategy about how to do this, the complaint only needs to set forth kind of the bare bones to get into court. You need to show the court that you're in the proper place and that something happened that was illegal. So, you can just have a very, skeleton, here's why the venue's appropriate. Here are, the short statement of facts, and here are the laws that we allege were broken. And that would be it. And that would be enough to get you through the door. And you're not limited to, what you've said in the complaint in terms of the facts. I mean, you can continue to develop those. There are other stages. Certainly when you get to trial, there are going to be a lot more things that come out. So you're not limited to what is in the complaint. That said, this is your opening salvo. This is what, it's going to be. If it's in federal court, it's going to be on PACER, which is the electronic filing system. In many state courts, they also have electronic filing system. It's a public document. And it's often the first thing that the judge is going to read. So one strategy is to make it as fulsome as possible, to include as many facts, to really, because there's really not no real page limit to these. I mean, you could file a complaint. There are some that are 100 plus pages. So you could really, provide a really long narrative in that fact section. Again, no right or wrong answer to that. As a legal matter, all you need is enough to show that you're in the right court, that something, illegal happened that the court can address, and enough facts to show that is the case. It's called the 25-cent legal term. It's called you'll hear people say a prima facie case, which basically is, you've set forth the bare, you haven't proved it, but you have set forth facts that shows there was a violation of law. So if we were to look at, for instance, let's say it was a personal injury case, the accident, and I'm going to state court in Arlington. And it doesn't matter whether you're in state court or federal court. All complaints within reason operate in the same way. But let's say I'm going to state court in Arlington. I would say, this accident happened in Arlington on this day. I was stopped at a red light, and, the car coming in the other direction crossed the yellow line and hit the front of my car, causing, damage to my car. And I had to go to the hospital. Well, that's enough to show that there was, and then you under the law section, there would be a negligent count, right? That the other driver didn't do what they were supposed to do. And that would be enough. You don't have to put what the weather was, was it, the extent of your injuries. You don't have to say what kind of car it was, like all those sorts of things. You just got to show the bare minimum to what we call state a claim. So, and the other thing to remember or to understand about this is, so you've got your complaint and you go, and then the next step is you actually file it. Sort of a simple step, but but sometimes I've seen people mess this up. You have got to, it's not been filed until now. Many times it's electronic, but back in the day, you'd go to the clerk's office and hand them a physical copy, and there would be an actual stamp, where it would be date and time stamped to show that it had been filed. Like I said, in many courts these days, you do it online. So, you just hit the file button and then you'll get a file copy back, but it's got to have that stamp on it by the clerk that says this, here's the complaint. It was filed on this date. This is particularly important if you've got statute of limitations issues. You're coming up on the last few days that you can file. You gotta make it in under the wire. You've got to be before the time that statute of limitations runs, and that's why it's important to have that file stamp. So you've done that. You've drafted your complaint. You've gotten it filed. You can always amend the complaint, right? So if you want to put, because things will come up during the case, and you want to assert another violation of law, you can file what's called an amended complaint. You want to add some more facts, you file and amend those facts. So you're not locked in to that first document that you file. And it's not uncommon for, people for parties to amend their complaint for one reason or another. Unless it's really, you're far down the track, the court's going to let you do that in most cases. So if you're in a situation where you're pressed for time and you're trying to beat a statute of limitations, and that's why sometimes you'll see people do a bare bones complaint because they're just trying to make it in under the wire. And, if you're sprinting down to the courthouse, it doesn't matter if all you need are 5 pages, to check that box, then you just run down there with the 5 pages, you get it filed. And then once that's done, you've met the filing requirement. So if you're within the statute of limitations, it doesn't matter how long it takes after this point, that issue has been satisfied. So you will see that in some occasions where somebody's up against the deadline, they just need to get something filed. They file it, and then they file an amended complaint later that has more detail, may assert different counts of law, and those sorts of things. So that's the initial stage. That's the first thing that's going to get the case started. Now, the second thing that needs to happen, and I'm going to actually do a whole separate episode on this because it is so in some situations so complicated. If you've not done this before, just because you have filed this complaint, good. That's the first thing you need to do. If you got statute of limitations issues, great. You've checked that box. You're fine. But the case has actually not been initiated because it hasn't been formally. You have not served it on the opposing party. And there's a whole set of steps that you have to go through to do that properly, that vary in some respect, depending on what court you're in and whether you're in federal or state court. But we will save that for the next time. So first thing you got to do is file the complaint. It's got to be in the right court, in the right jurisdiction. You got to set forth just enough facts to show that there's been a violation of the law. You don't have to prove your case at this point. This is important. You don't cite case law and all that. That's for later. It's just the facts and the laws that you believe are violated. I will say also for those, it's obviously better if you have a lawyer. This is very complicated. But if you are pro se, and by that I mean you're representing yourself, I find that most courts are really go out of their way to help you. It doesn't hurt to be friendly with the clerk. They can be of great assistance to you, but in terms of just meeting the bare minimum that you need to start the case, that complaint doesn't have to be perfect. I wouldn't recommend this, but you could handwrite it, right? I mean, there certainly have been cases that have been initiated that way. So, because the courts understand that you're not a lawyer, and if your caption isn't perfect or if you don't state things exactly the right way, the court's usually not going to penalize you. If they do, and this is after service, and we'll get back to it later, sometimes what they'll do is they will dismiss the complaint with what's called without prejudice, which means you can refile it, and they'll give you some kind of direction, like, hey, you haven't stated enough here to state a claim. You need some more facts. So anyway, if you were filing pro se, your complaint doesn't have to look the same way as if a lawyer filed it. The court's not going to expect that, but you do have to meet these bare minimum requirements. So now we've done that. We've got the file stamp, and the next step will be actually serving the complaint on the defendant, and that will be in the next episode. If you would like some more information along these lines, the latest and greatest in employment law, and also tips and tricks on how to keep your career on an upward trajectory, you can check out our free site. It's called thecareerrocket.io. You got to put the in front of it. So thecareerrocket.io, where we provide a lot of information, including other episodes of this podcast. And you can enter your information and you will get a weekly free email where we share the latest and greatest on employment law and employment trends. So go there if you'd like some more of this. It would be a big help to me if you found this useful to like and comment on whatever podcast app you use to listen to this. You can give us good remarks. It helps people find us and helps us get this to other folks. All right. I hope this was helpful. We'll talk to you guys next time.